Florida's House Bill 913 officially ended the period where community boards could use video conferencing without strict oversight. The state has replaced casual operations with intense compliance guardrails. For condos, co-ops, and HOAs, this means following a specific start-to-finish workflow to ensure every hybrid meeting remains legally valid. Simply clicking Start Meeting without configuring the necessary advanced mechanics invites statutory violations and legal complaints from residents. Mastering the specific checklist in this video protects both the homeowner's rights and the board's legal standing. Your physical and digital meeting notices must now perfectly mirror each other. These must still be posted on the property at least 48 hours in advance, or 14 days for budgets and assessments. Every notice needs a clickable video link, a local or toll-free phone number with meeting ID, and the exact physical address of the meeting site. Some boards assume virtual means they can stop hosting meetings in person. Florida law considers a 100% digital meeting that locks out in-person attendance to be a structural statutory violation. You must provide a physical room, like a clubhouse or office, equipped with a two-way speaker system. Owners in that room must be able to audibly hear the board members on the screen, and the remote board must be able to hear the owners. Your setup passes the legal test if an owner without a computer can walk into that room or dial in via a traditional telephone and still participate. No matter how digital your community becomes, a Florida virtual meeting requires this accessible physical anchor to remain valid. For regular board meetings, members participating via real-time video conference count toward a quorum and can vote as if they were physically present. This rule changes significantly during a condo or co-op's annual membership meeting and board election. On election night, a board quorum must be physically present together at the meeting location. Owners can stream from home, but directors must stand before the members in person. Boards also face a major legal blind spot when discussing pending litigation with their association attorney in closed executive sessions. The video conferencing statute does not explicitly exempt legal meetings from the recording mandate. To protect attorney-client privilege, do not use Zoom, Teams, or Google Meet for these sensitive discussions. Hold these sensitive legal meetings entirely in person, or use a traditional audio-only teleconference phone line to shield your legal strategy from recording requirements. If you conduct a meeting via a video platform, you are legally required to record both the audio and video. Hit the record button the exact second the meeting is called to order. To maintain transparency, designate a property manager or administrative assistant as the digital host. A voting board member should never be the person controlling the software. This prevents the perception of censorship. Florida law explicitly protects owners from being digitally silenced, and boards cannot use the Mute All button to block residents from speaking on agenda items. Voting also requires specific audio clarity. Board members cannot cast votes via email, so the chair must conduct a verbal roll call for every motion. The recording must capture a clear aye or nay from every director. Before any final vote, the chair must explicitly open the floor for member comments. The host will then systematically unmute residents, giving them their legally protected time to voice their opinions. Following this sequence of structured comments and roll call votes protects the board from accusations of silencing the community. The audio and video files saved from your session immediately become official association records under Florida law. If your community has 25 or more units for condos or 100 or more parcels for HOAs, you have a mandatory digital upload requirement. Under the 12-month web mandate, you must post the video recording, or a functional link to it, on your secure member website. It must remain accessible for at least 12 months, alongside the approved written minutes. A virtual meeting concludes legally only after its digital footprint is secured, uploaded, and made accessible to the membership. You now have the specific requirements to safely anchor digital convenience to Florida's physical and legal meeting mandates. By ensuring proper notice, maintaining a physical location, recording every second, and archiving the results, your association remains compliant with the newest state reforms. You can download a complete virtual meeting compliance checklist in the video description to share with your management team. Strictly following these steps insulates the association from state complaints, procedural lawsuits, and the risks of Florida's strict new governance standards.